I want you to imagine something. I want you to imagine something. Imagine being accused of a crime and the court has pronounced you not guilty of that offense after the whole trial has been conducted. By the evidence you people were brought before the court has examined those evidence and found you not guilty and therefore released you from the custody of the police or wherever you may have been. Then only for you to wake up tomorrow again, or only for you to witness within a week interval that you are being asked or you are being taken again by the police, and you asked what is the problem, and they said it's because you murdered somebody, or it's because of that the same offense of kidnapping, because of that the same offense of rape that you were involved, you were alleged to have been involved. That is why we arrested you today again. How will you feel? Or come to think of it again, you have been convicted of a particular crime and you have suffered it for 5 good years in prison, and after everything they released you when you have suffered your punishment. And in next month, they arrested you again and you ask what is the problem. I thought I have repented. I thought I have given my life to Christ. Why are you disturbing me again? And they said, you know what? It's because of that very offense. The court didn't do justice to it. We are arresting you again. How will you feel? You feel bad, right? That is what basically today's video is all about. We are considering Autrefois Acquit Autrefois Convict. What is it all about? Because there's no need of blowing English and speaking a lot of grammar. This is a practical example of what we are going to do today. And at the end of this video, believe me, even if your lecturer wakes you up from sleep, even if anybody wakes you up from sleep, you are going to do justice to what Autrefois Acquit is all about and what Autrefois Convict is all about. So the question now is, what is Autrefois Convict? Let us start from there to give it a flesh. Autrefois Acquit is just a French term that formally means acquitted. These principles say that if a person has been tried and acquitted for a crime, they cannot be prosecuted again of the same offense. So the Autrefois Acquit is basically a defense that operates in the realm of criminal law, in the sense that it is a defense that is geared to avoid double prosecution of a person on the same fact after the person has been duly tried, discharged, and acquitted. Those where an accused is charged with an offense, and after full trial and conclusion of the case, and the court discharges and acquits him or her, the person cannot again be arrested and tried for the same offense. If he or she is discharged, the person will simply plead Autrefois Acquit. That is to say, he or she has been previously tried and acquitted of the same offense. Do you understand? All this whole English, all this whole analogy is that if you have been acquitted, acquit or acquitter simply means to declare not guilty or to found not guilty. That is to say, if someone has been adjudged by the court as not guilty of offense, that is what we mean by acquit, Autrefois Acquit, meaning that the court has examining the evidence leveled against you. Remember, Section 36 of 5 of 1999 Constitution, applicable in Federal Republic of Nigeria, says that anybody who has been charged with a criminal offense shall be presumed innocent until proven guilty. So for the fact that you are linked up with a particular crime doesn't mean you are guilty of it. If the court has examined evidence before it and says that in line with this, you are not guilty of the same offense, you are not guilty of this same rape charged on you, you are not guilty of this murder, you are not guilty of kidnapping, if the court has adjourned you not guilty, it means that the court has granted what we know as Autrefois Acquit. And this then it becomes a defense to you if you were charged again on the same offense. I don't know if you are making a point here. If the court has decided your matter and say, go in peace, go home and sin no more, or go home, in fact, you didn't commit any sin. If the court has adjourned you like this, and any person try to bring you to the court again on the same offense, you can simply raise the defense of Autrefois Acquit. My lord, This matter has been tried. Please save me from this double jeopardy. The purpose of Autrefois Acquit is to save the accused, save the person that has been linked up with a crime from double jeopardy. You cannot be prosecuted over, like example I gave you when I was beginning this video, when the court have say you should go, only for you to reach your home, they again arrest you. It's an emotional challenge, and the law does not encourage disturbing the lives of the citizens. The law is there for the purpose of for our welfare, for our goodness. So the law doesn't encourage multiplicity of action, neither does the law encourage all this kind of injustice on you. So because of that, once you have been adjourned not guilty, no person can bring you to the court. And if they try it, you can simply raise the defense of Autrefois Acquit. That is to say, you should now go with the idea that Autrefois Acquit is a defense where in criminal matters. If you have not watched my video on the one that has to do with civil matters, go and check that very video, because that one has to do with res judicata. You can click the link above after watching this video, or go to my description section in my playlist. You can browse through and see that very video that explains res judicata, because the two of them go hand in hand. Now, let us proceed to another one, which is Autrefois Convict. But before we go there, have you subscribed to my channel? Yes, have you subscribed to my channel? Please, if you have not subscribed to this channel, I beg you to do so, because this channel is dedicated towards bringing everything that concerns the law. It is dedicated to answer all your questions, both in contract, both legal system, both thoughts, any law you could think of, criminal law. That is what this channel is all about, to answer all your questions. It's where we help each other to grow. If you have questions, you can always put it on the comment section. All of us will help to answer you. This is your #1 place as far as studying of law is concerned, as far as knowing the legal updates is concerned, as far as seeing how the political updates shape the law and how the law shape the politics. That is what this channel is all about. Subscribe and like this video. I believe you have done so. I had it. Thank you so much. Now, let us proceed to what? Autrefois Convict. We have considered Autrefois Acquit. Now, let us consider Autrefois Convict. Autrefois Convict simply means formally convicted. If someone, that is to say, if someone has been convicted of a crime, they cannot be prosecuted again for the same crime once they have served their sentence or pardon. The defense of Autrefois Acquit is aimed to avoiding double jeopardy of trial and punishment to accused who has been tried and convicted on same fact. If someone who has been tried and convicted of an offense has served the punishment due for it, if the person is to be tried again on same offense, he or she will simply plead Autrefois Convict, meaning that the person has been tried, convicted, and punished for the same offense, and therefore should be spared of this double jeopardy. Do you understand? It's just a clear language that if I have been tried and convicted and sentenced to 5 years imprisonment for doing this or doing that, and I have served that punishment, and I come back tomorrow, you cannot just wake up and raise that very offense against me. You cannot take me again and try to prosecute me over offense which I have served. The difference here is why the other one is Autrefois Acquit, that I have been exonerated, I have been released of this crime linked up to me. Therefore, I will not serve that punishment, but I have been released. I have been found not guilty. I have been found not wanting before the law. That is what that one means. But this one, on the other hand, means that I was convicted, yes, I was found guilty, but I have served the punishment. Therefore, don't punish me again. All of them is the same thing, which is geared towards saving the citizens from double jeopardy. The law frowns at double jeopardy. The law doesn't like double jeopardy. The law is against it in all ramifications. That is why this principle is regarded as common law principle. It has its origin from the common law, and almost all the jurisdictions of the world adopt this principle because it is relevant for the sanctity of any legal system to succeed. This thing must be there. This element of Autrefois Acquit and Autrefois Convict is very cardinal principle that is highly needed for the success of any legal system. Otherwise, there will be anarchy. There will be chaos. You can just come back again because it is the state that prosecutes. Mr. President can order the Attorney General to rearrest you. He will keep rearresting you until his tenure is over, possibly because of political ambitions and missions. So because of this defense is geared towards saving you and I from double jeopardy. Whichever way around, whether you are found guilty or you are not found guilty, this defense is always available. But I want you to know that this There is difference between this defense as far as concerns appeal. That is to say, if there is a case, if the state, because it is the state, I believe by now you should know that it is the state that prosecute. If you don't know that it is the state that prosecute, go and watch my video on essential basic terms all law students must know. Go also see my video on introduction to legal method and that of legal system. All of them is in the playlist. Go and check, browse through and see all of them. It is the state that prosecute. Because it is the state that prosecute, in this case now, if the state, first of all, a case will always begin at the trial court. The trial court could be state high court, depend on the jurisdiction where you are watching this video. That trial court, if that trial court has given a judgment in your favor that you are not guilty of rape, you are not guilty of murder or any other offenses that may have linked up to you, the state still has the right to appeal, to take it to the Court of Appeal and subsequently to the Supreme Court, depending on your jurisdiction. That does not mean that if the case tries to appeal, you will raise the defense of Autrefois Acquit or Convict. No, the matter has not been fully decided. That's why if you go and watch my video on res judicata, I told you there are 4 conditions there, stated in the case of Mark Onova's Federal University of Technology, Mina. I told you there are defenses there, the conditions there rather, that must be followed, that must be in place for you to raise it. So also it applies here. The matter has not been finally decided in the sense that it is only the trial court that decided the matter. The matter has not been fully litigated upon. It has not been, all the options are not fully been exhausted. Once all the options has been duly exhausted by the party, any party, it means that the matter has been finally decided. In this case, the trial court has given judgment. I'm still not comfortable with it. I can appeal. I can subsequently still appeal to this, because once Supreme Court has decided it, law, you cannot do anything against it, both in this world to come and in the world to come. Even in your dream, you cannot try it because the matter has been decided. If you raise it, the other party can simply raise me, Lord, Autrefois Acquit, save me from this double jeopardy. That is what it is all about. I believe you are getting this value in this video. If you are getting value, please press that like button. If you are confused, if you need a clarification, put it in that comment section. Whenever I come, I'm going to answer you. Always there to help you, because we help each other to grow. As we have considered it now, remember, one thing I stand for in this channel is that I'm not just here to give you definitions. I'm not just here to explain to you so you will know what Autrefois Acquit means, because you are a law student or you are a legal person. Even if you are not a law student watching this video, you are learning a law, and in law you don't assert without a proof. He who asserts must prove, because even section 131 and 136 of the Evidence Act, applicable in Federal Republic of Nigeria, state that whoever wants the court to rely on a particular fact and figure or evidence to give a judgment in his matter must adduce evidence that substantially proves that those facts exist. It is still a common law principle that he who asserts must prove. If you have stated something, you must prove it. Now, that's why I'm trying to tell you that in this channel, I will not only give you definition, I will give you authority you are going to use to answer this question. What are the authority you are going to use to answer this question? Where should we start? Should we start in statutory authorities or case law? I think it will be nice we begin with statutory authorities. The statutory authorities backing this very Autrefois Acquit, as far as this very discussion is concerned, is Section 36 sub 9 of the 1999 Constitution, which is applicable to Federal Republic of Nigeria. However, even if you are not within the jurisdiction of Federal Republic of Nigeria, once I state what this very section says, you can always trace it to your own constitution, because it is something that is of common law origin. Now, let us consider the provisions of that very constitution for the purpose of this video. Let us read section 36 sub 9 of the 1999 Constitution. That section says that no person who shows that he has been tried by any court of competent jurisdiction, very important, any court of competent jurisdiction or tribunal for a criminal offense, and either convicted or acquitted, shall again be tried for that offense of a criminal offense, having the same ingredient as that of the offense, saved upon the order of court. No person who has shown that been tried of a particular offense shall be again be brought back over that particular matter if the court has fully determined that matter. Like I pointed out in that res judicata video I made, I pointed that condition, which is that it must be same offense. 1, it must be the same party. 2, it must be the same subject matter. And then the court must have been a court of competent jurisdiction. Court of competent jurisdiction means that the court must be a court that has the right to determine that matter. If the case has to do with felony, for instance, under Nigerian system of legal system. It is the Federal High Court that will adjudicate that matter. In other words, if you take the person to the customary court of appeal or to the customary court, that court don't have jurisdiction, because even section 36 sub 12 says that before you can convict anybody of the same offense, that offense must have been stated down. Nullum criminum ponem sine lege is a principle in common law which says that you cannot convict a person over offense that is not clearly written down or stipulated. This is something that is provided in all jurisdictions of the world. And in case of alcohol verse 5, it's relevant there, which says that you cannot, adultery is not a crime in the southern part of country. Therefore, nobody should be convicted on that same offense. I'm trying to tell you here is that once that court has the competent jurisdiction over that matter, once the court that decided that matter is not a court that is not a court that doesn't have jurisdiction and the matter have been discussed, you cannot bring it up again. That the idea of me bringing that section 36 sub 12 is to illustrate the principle that if you take the person to the customary court, in this case customary court doesn't have jurisdiction, because customary court is deemed to adjudicate on matter that is not written down, and in criminal law it is only a crime that is written down that will be punished. It is only a crime that is stipulated that the law can punish anybody on. This section 36 sub 9 is saying that if you can show that that matter has been tried finally, not just by a court that doesn't have jurisdiction. 2, if you can show that it is the same party. 3, if you can say that it is the same criminal offense, same ingraded offense that you are being prosecuted, the court will avail you from double jeopardy. That is what that section is all about. I hope you have seen authority you can use to back up your Autrefois Acquit and that of Autrefois Convict. This section 36 sub 9 deal with it. Now let me give you case authorities that has to do with this. The simplest judicial authority I have for you as far as the Autrefois Convict and Autrefois Acquit doctrine is concerned is that which is decided by Nigerian Supreme Court. In the case of Nigerian Army vs. Aminu Kanu, it was a case that was decided by the Supreme Court in the year 2010. That very case illustrates the principle. The Supreme Court in that very case stated that where a person has shown that he has been tried by a court with requisite jurisdiction, that person should not be disturbed or vexed upon that same crime. At this point, permit me to tell you that your knowledge in this video is not yet complete until you watch my other video that has to do with res judicata. What Autrefois Acquit and Autrefois Convict is to criminal proceedings or procedure is what res judicata is to civil proceedings. There are two things that are, though quite similar in operation with regard to civil and criminal, they mean the same thing. So it's something you have to watch out for so that it will aid your understanding in this very video, which has to do with criminal proceedings. So to see that video, click the link above. Yes, this link will direct you to that video so you watch res judicata and see how it relates. Please don't forget to subscribe to this channel. Yes, I believe you have subscribed to this channel. If you have not done so, please subscribe to this channel. That is the only way YouTube will recommend a video like this to you. Remember, we help each other to grow. So subscribe to this channel while you go and watch this video above. I'll see you in my next video.